Well, welcome back to King County Law Library's What to Expect When video series. Our returning expert is seasoned family law attorney Rosemary Lemoyne, who is going to talk to us today about family law motions before commissioners, family law motions before family law judges, and submitting motions and proposed orders. Welcome back, Rosemary. Great to have you.
Thank you, Rick. I certainly feel seasoned, but I don't.
Well, let's start out by assuming that I'm a person who's representing myself in a family law case, and I know I need to present a motion. How do I know whether it should be heard before a commissioner or before my family law judge?
Well, you have a family law judge, a family law commissioner, and an ex parte commissioner. So there are three places where your motion can be heard. First, if it's a family law motion, that's a motion in your divorce, or maybe you filed a paternity action to establish a parenting plan for a child or child support for a child. That motion is going to be heard in the family law department, normally by the family law commissioner. If it's a motion to change your trial date, you filed the case, you got your case schedule, and it tells you on such and such a date is your trial, but you need that date changed. That's going to go before your assigned trial judge, and you'll see his or her name on the first page of that case calendar, that case schedule that the clerk gives you when you file. Now, ex parte is a different courtroom. In ex parte, you're going to be filing motions such as a default motion if the other side has not appeared at all, and you're asking the court to grant the relief you requested. Or if you've got an agreed order in a case and your opposing party has signed that, you can submit that to ex parte. Ex parte department hears all types of motions concerning adoptions, evictions. They will also hear emergency motions, and certain emergency family law motions are heard in ex parte. The clerk's website offers a link to King County Local Family Law Rule 5. And that rule, Local Family Law Rule 5, tells you exactly what ex parte hears, what family law hears, and what your trial judge hears. The other link you can look at when you go to the website for the King County Superior Court clerk is a link that they have to each of those departments. And the ex parte department has published a list of all the motions they will hear. That list is about 18 pages long. But many of these, probate guardianship motions, domestic relations, but different things, a temporary anti-harassment order, or a temporary order in domestic violence matters, for example. Those are heard there. Adoption motions, as I mentioned. The link to finding out what's heard in ex parte can be found at dja-eweb.kingcounty.gov/ex parte, EXPARTE/public list, ASPX. And that will bring you to that list.
Okay, so I now know that the motion I want to present needs to be in front of a family law commissioner. How do I do that now with the current procedures?
Go to the King County Superior Court website, follow the link to the clerk's website section of that website, and there you will find a link to choosing a date. You're going to choose a date on the King County Family Law Motions calendar. People representing themselves have certain days on which they can schedule a hearing. If your case has at least one lawyer, perhaps representing the other person, then you must go on other dates for those hearings, other days of the week.
Okay.
Also, when you look at that, remember for a family law hearing, you have to give at least 14 days advance notice of your hearing. You can count holidays and weekends when you count for a period as long as 14 days. My advice to you is to go longer than that, and given the fact that there's a cap on the number of motions that can be heard each day, you probably will have to go longer than that. Sometimes folks will say, well, when I picked a date, nothing happened. That means that day is already full. There are already as many motions set for that day as can be set. The motions are heard at 1:30 in the afternoon. So when you look at that and you choose your date, let's assume it's 3 weeks out. You will then fill in all the information that is requested. Your name, it's a family law motion. Then one of the pop-up links will say what subtype motion. Is it a motion for temporary orders? That would be a motion for maintenance, what we used to call alimony, child support, a parenting plan. Maybe you want to live in a house and your partner or spouse is living there and you'd like the court to require him or her to leave so you could go back to the home. That's also a motion the court hears. All of those are set at that 1 p.m. calendar and on a date that is at least 2 weeks out, as I mentioned. Once you've picked that date and you filled out and you said this is the sub motion, then it'll ask information about yourself, your email address, your phone number. This is critical. Remember that all hearings now are by telephone. Give a phone number where you can be reached, not a phone number where the commissioner will have to go through several receptionists or other people, but a phone number where you will be sitting and waiting for that phone to ring on the day you've chosen for your hearing. Then you have to provide that information about the other party. And Rick, I wanted to mention something here very important for folks. When you set that motion, remember, your papers are going to be e-filed with the court, but you need to get a copy to the other party. And if the other party has signed up to accept papers by the e-filing system, that's great. It's very easy. But if they have not, you must mail them to the other party. As long as it's not a motion for contempt and a few other types of motions that have to be filed and served with special certified mail, return receipt requested, you can mail just regular mail. I do not advise that though. I advise that you mail 1 copy regular mail and 1 copy certified mail, return receipt requested, so you have proof you mailed it. When you put it in the mail, be sure to write down the date you mailed it, write down the address you mailed it to so you have some proof, because often the commissioner will ask you, if the other side does not appear at the hearing, do you have any proof you served the other party with this motion? So that's very important. And remember, when you use mail to serve a motion, you have to add 3 days to the notice period. 3 days are added to the notice period. So it was 14, now it's 17.
Okay. Thank you, Rosemary. And so what if I need to present more than 1 motion? How is that done now?
You would file 1 motion, for example, that's about support. You want child support, you want support for yourself. Maintenance was what we call it. It used to be called alimony. And perhaps you also would like some money to hire an expert witness or to hire an attorney. And maybe you'd like a motion that says you want the use of the family's car. That can be combined into 1 motion for temporary orders.
Okay.
Remember, the forms are on the court's website, the Washington State Court's website, and the King County Clerk's office also has a helpful link to those forms. But let's pretend you have these motions for temporary orders in the case, but there's also another order that your partner or spouse is not following that was previously entered, and you want to enforce that order. We're not going to go down the contempt route. That's a little more complicated. Let's just assume you want to file a motion to compel compliance with a prior court order. Maybe the court already ordered the other spouse or partner to pay child support or to give you time with your child, but hasn't been doing that. That motion to compel compliance, to require the other person to obey or to follow a court's order, that's separate from your motion for temporary orders, and you have to prepare another set of motion documents. And motion documents go in triplicate usually. You've got your note when you pick your date, your motion, and which usually includes your declaration. Your declaration or your statement can be separate, and your proposed order. You're going to have to go back to the calendar on the clerk's website and select a date for that motion as well. If you would like to argue it the same day, present it the same day as you're presenting your motion for other temporary orders, you can see if there's another slot available for that hearing.
Okay.
Just try, but if there's not, you'll have to pick a different date because there is a cap on the number of motions, and those motions are taken very quickly.
Yeah.
Many people are trying to file motions on that date, and it's accessible.
A busy part of the court. Yeah. Okay. Well, thank you, Rosemary. So let's now talk about, let's assume that I know I'm representing myself in a family law matter and I need to present a motion, and I know it needs to go in front of my family law judge. So how do I do that these days? How is that different?
The judge gets a different note for motion docket or a different calendaring, notice of motion, notice of hearing form. Go again to King County Superior Court's website, the clerk's section of that website, and look at forms. There's a handy link to forms, commonly used forms. There's one link that takes you to the state forms and another link that takes you to forms used in King County. You'll go to that link for King County forms, and then you'll go down that list of forms until you find notice for presentation to your assigned judge. Now, if you're a Kent case, remember all cases south of I-90, except for Mercer Island, are assigned to Kent. Cases north of I-90 are assigned to downtown Seattle. And you can look that up to find out when you're filing your case, where is my case supposed to be filed? You can also call the clerk's office if you're unsure, and they'll help you determine where you should be. Our form is called Notice of Court Date. And let's pretend you're in a Seattle case. You're going to check the boxes that apply. Is this motion without oral argument? For example, if you want to change your court date, your trial date, that's without oral argument. If you're asking the judge to allow you to revise a court commissioner's decision in your family law matter, that motion must be filed within 10 days of the date on which the commissioner signed the family law order. And you would then note a motion before your trial judge, your assigned trial judge, to revise that decision. When you note that date and you select your date, you're using this notice of court date, you'll be providing a copy of this to the judge's bailiff. Often that date will need to be changed because judges have very busy calendars packed with trials and other motions. But the bailiff will let you know what date works or what date you're assigned to. So when you choose your date, if it's without oral argument, you can choose any date that you like. Now, if you have a doubt about what a court day is, there are a few days in the year which are non-judicial days that are not federally recognized holidays. You can contact the clerk for the information to be sure that this is a day that the court will be in session. So you fill out that form, sign it, and then you prepare your motion to go along with the form that you're going to be submitting to the judge. And again, it goes in threes: the notice of court date, your motion, your proposed order. And with your motion for your judge would also go a declaration. So that's 4 things you're going to be presenting. And again, the same process for mailing the motion to your spouse or partner applies. Add 3 days. And when you count those 3 days for mailing, you don't count the first day. You start counting, pretend I'm mailing it today, Wednesday. I would count Thursday, Friday, and I get to count Saturday. When you're counting the days for mailing, you do get to count Saturdays, Sundays, and holidays.
Okay. All right, thank you, Rosemary. It's complicated, but you're doing a great job of making it as understandable as possible. So one final thing has changed recently in family court, and that's the presentation of proposed orders. Can you speak a little bit about what's changed there?
When you have, when you filed a motion, you have to file that proposed order.
Mhm.
And in that proposed order, you're going to tell the court what you hope the court will order. Attorney's fees, maintenance, child support, all of those things will be filled out. In fact, child support's a separate order, proposed child support order and proposed child support worksheet.
Mhm.
Those have to be filed with the e-filing system for King County Superior Court. If you do not have access to a computer and cannot use e-filing, please telephone the court clerk to find out the process for submitting those records,
Mhm.
those proposed orders. When you go to King County Superior Court e-filing, you will sign in. It's free to sign up for a program or for the ability to use the program, and I encourage you to do so.
Mhm.
When you sign in, you'll see there's a link at the very bottom which says proposed orders. That will take you through some things you have to fill out. You fill out those forms, your name, your email, the case number, the date of the motion, and then it will say upload a Word copy of your order. It must be in Word, and you upload that to the site so the clerk can hand that to the commissioner or email it to the commissioner for your hearing.
Excellent. Well, that covers everything we wanted to talk about today. So thanks again, Rosemary, very much.
Could I
Do
add
you have
something?
anything else you want to add? Yeah.
I was concerned that folks might not know. In the old days, we used to confirm by telephoning
Mhm.
in for a hearing, and this is on family law. And now you have to fill out a list of all the documents you're submitting. That index of documents you're submitting is very important. If you don't fill that out and submit it, your hearing will not go forward.
Mhm.
The link to that is also found at the court clerk's website, and it's a wonderful form. Fill that out. It does say docket numbers. The docket numbers are the numbers assigned by the clerk to a document when you file them. If you don't know the docket number, don't worry about that. Just list the documents you're providing. Remember, when you list those documents on that form and you submit it, that's saying I will be coming for my hearing. Now, in a motion, when family law, we give 14 days notice. Now you have to file your response 5 days before the hearing. So if you're receiving this motion, 5 court days by noon, you must respond in writing.
Mhm.
5 days means you don't count holidays, you don't count Saturdays, you don't count Sundays. When you submit your response, you also must file an index of all the documents you are submitting. Don't forget that.
Mhm.
Then when you reply to that, pretend you're the person that filed the motion. You get a chance to reply. When you reply, yeah, I was about to say, but I want to be sure it's 3. Your reply is due 3 court days before the hearing, before noon. 3 court days means you do not count Saturdays, you do not count Sundays, you do not count holidays. Before noon, not just to the court, but to the other party as well. And you must again file that index of documents you are submitting for the hearing on the form the court gives you. It's a free form. Again, the link is found at King County Superior Court, the clerk's website. When you file a motion, go ahead and file that form. When you respond to the motion, you must file that form. When you reply, file that form. Some people have said, well, I can wait to file the form until 3 days before the hearing. You can, but it's risky. Please file the index of the documents you're submitting when you file your motion so that you're sure you're confirmed.
Thank you, Rosemary.
Oh, thank you, Rick. Thank you for all that the library does. You are just a gift to the people of King County.
Well, thank you again for all of your time and all of your expertise.
Oh, Thank
Bye-bye
you.
now.
Bye, Rick.